Coming up next, the Writers' Watch Legislative Conference examines how the writing profession deals with national security and weighing official secrets.
Okay, I think we're going to get started. Our last panel of the day is on national security secrets, and Jeff Morley, sitting here beneath me, is the Washington editor of The Nation, who will be moderating the panel today.
We're still waiting for Christopher Hitchens, but we were planning on having him speak last, so we'll just get going and hope that he comes in the interim. I'm going to introduce our panelists today. Welcome all to the Writers' Watch Conference. We're going to be talking about secrecy, an issue very much in the news. Perhaps the most interesting recent development was Congressman George Brown's resignation from the House Intelligence Committee and his comments surrounding it about the role of secrets in the government and the frustration he felt. A longer time ago, back in 1980, Frank Carlucci, then Deputy Director of the CIA, was speaking to the American Bar Association about this exact same subject and about legal constraints on secrecy and oversight of the intelligence process. And Carlucci told the Bar Association that he thought that the present process, the finding process, the process in which covert actions are approved via presidential finding, and with the resultant congressional oversight, was an adequate system for overseeing this country's intelligence operations. And he said, you just have to trust all of the people involved, the people in Congress, the people in administration, and the president. And if you can't trust them, this country is in very deep trouble indeed. I don't know. For his wisdom, Mr. Carlucci has been appointed to the Secretary of Defense. I don't know if we would all agree with him that the country is in very deep trouble indeed, but the process of officials of secrecy in government is certainly in question, and that's what we want to get to today. First speaker is Morton Halpern from American Civil Liberties Union, the Center for National Security Studies, and I'll just get to him.
Thank you. I think I will be very brief because I suggest that the next two speakers will say things that most of you will find more controversial, and I think we should leave whatever time there is for debating that. Let me just make a few points on which I think that there is a consensus on the following points. First, that there is some information that the government has a right to keep secret. Second, that much more information is kept secret than is in that first category. Every study that's been done on the subject by everybody, including all official studies from within the government, have always concluded that much more is kept secret than should be, and that the fact of the fact of overclassification and over-secrecy is one of the enemies of effective secrecy. As Justice Stewart said in the Pentagon Papers case, when everything is secret, then nothing is secret. And that one solution to the problem that everybody agrees should be done is to keep less secret. Unfortunately, nobody knows how to have less information made secret, and that is partly because there are a range of bureaucratic and organizational reasons why things are kept secret, and often things are kept secret precisely to keep them from those who would stop them. And we had almost an endless caricature of that in the Iran-Contra hearings. Take just one of the many vignettes when Admiral Poindexter was asked why, to put it delicately, he lied to the Congress about what Colonel North was doing. He said if you found out what he was doing, you would have stopped him. And we didn't want you to stop him, and so we didn't tell you what he was doing. That is not the sole reason for secrecy, or even quantitatively the most important, but I think qualitatively it is, and it is the motive for secrecy that raises the most serious constitutional questions in a society with a First Amendment and a dedication to participation by the Congress and the public in these issues. The system we now have is, I think, very much, what one should say about it is very much what Winston Churchill said about democracy, which is that it was the worst system we had except all the others. And the system we now have basically is one in which the government is free to try to keep things secret through a variety of means, and the press is free, and others outside the government are free to try to learn as much as they can, and with a few narrow exceptions of things like atomic energy and communications information, were, at least until fairly recently, free to publish that information without threat of criminal penalties. Now, as I say, that's a very untidy system. It is one that does not appeal to anybody who believes you should decide what should be kept secret and keep that secret and then publish the rest. But by and large, it's actually worked reasonably well. The government has occasionally even succeeded in keeping things secret that ought to be kept secret. More often, the press has learned about it and chosen not to publish it. And we have learned some, but not all, of that information, which I think the public is entitled to participate in public debate. There are some orderly things that could be done. One that the Carter administration did, the Reagan administration took away, was to put a balancing test into the classification order to require the bureaucracy to take account of the public's right to know, as well as the harm to national security from releasing information, and to make that a part of the Freedom of Information Act so that the courts can also balance national security against the public's right to know. Another thing that could be done is for Congress to use the authority it gave itself in setting up the House and Senate Intelligence Committees to engage in an orderly process through which the Congress decides, despite the objections of the executive branch, to make information public. That procedure exists. It has never been used to make information public, and I think it ought to be used at least occasionally, if not regularly. Now, from the other side, one has to point out that we are in the process of changing this whole system in a fundamental way, which in my view poses the most serious threat to the First Amendment we are now facing, and a threat of extraordinary gravity. And that comes from the indictment of a man named Samuel Eliot Morrison for what the government chose to call espionage and theft. Mr. Morrison gave information that he had acquired as a result of, and to some degree because of his official duties, to Jane's, a British publication, which in turn published it. He was indicted and convicted. He's the first person in the history of the Republic to be convicted of the crime of giving information to the press for the purpose of publishing it. And he was convicted both under the espionage statutes and also under the theft statutes, which would extend this not only to national security information, but all information that the government wants to keep secret. His motions to dismiss the indictment failed. He was convicted. The case is now on appeal. It's been argued in the Court of Appeals, and we're awaiting a decision of the Court of Appeals. If that conviction is sustained at the Court of Appeals level and then by the Supreme Court, we will have an Official Secrets Act which will make us wish that we had the British system. It basically will permit the government to label any information as secret, whether on national security grounds or on any other grounds, and it will then make it a crime for a government official to give it to a reporter or anybody else, for the reporter or any other private citizen to receive it, to transmit it to anybody else, and there will be no defense relating to whether the information had previously been public. There will be no defense relating to the motive of the decision, and the government's burden of proof as to what injury would result will be so tenuous that it would be extraordinarily difficult, if not impossible, to ever mount that defense. So I think that those of us who think there ought to be more debate and more public information on national security ought to understand that what we are in fact facing is the grave danger that there will be far less. Thank you.
Our second speaker will be David Holliday, Special Assistant to the Chairman of the Senate Oversight Intelligence Committee.
I want to thank my friend Mort Halper for telling me two things that I enjoyed. One was that anyone from the ACLU would say that they were going to be brief because someone later was going to be controversial. That's a delightful statement. And the other for saying that there are some things that should be kept secret. Well, I agree, Mort, with you on that. I'm not sure it's quite as universally held as you may as you may think that it is. The comments that I want to make, I'm going to bracket by a couple of statements. One is that anyone who is looking for justification to publicize national security information will find it. Conversely, anybody who is looking for justification not to publish national security information will find that too. Very seldom are these things ever black and white. There's always good arguments, very cogent arguments on both sides about why this should be done and why this should not be done. The other bracket I will give you is that responsibility for maintaining a free society cannot be lifted from the shoulders of any member of that society. Now, in between, I'll point out a couple of things. I think from my point of view, I am not nearly as concerned about certain secrets that end up being published, either in the media or privately through books or in other fashions. I am not nearly as concerned, for example, about the articles that appear dealing with covert actions that the United States may or may not find itself engaged in. Those are the things that usually, from the media standpoint, end up in the press more often than most other activities of the intelligence community. As I'm sure, as most of you know, covert actions are an exceedingly small part of what the intelligence community does and what it's about. But those are the things which end up most titillating the public and most sought after by journalists, is what is the United States doing in the covert action area, what will they do, what have they done, and did they do it right when they did it. I am not nearly as concerned about that. Frankly, although I don't think it's a good idea, and I certainly am not going to help anybody attain it, I think that if every covert action the United States was involved in was made public tomorrow morning, the nation would survive. It would not be as devastating a blow as most or a great many people, particularly in the intelligence community, would think that it would be. Again, I don't recommend it, and I'm not going to help anybody get there. But that does not concern me nearly as much as areas such as, for example, collection, sources and methods, intelligence collection. How do we do that? Where do we do that? Under what circumstances do we do that? Those things, I think, are very important. To a lesser extent, but also very important, is analysis. What does the American intelligence community think about any given subject or a given country or a given leader? Those kinds of things, to me, are far more important as far as the nation is concerned than are covert actions and whether or not we are or not engaged in those. It is much more of a concern to me that the Washington Post runs stories on the Ivy Bells operation, for example, than it is that Bob Woodward runs a story on whether or not there is a Libyan covert action operation as they did a couple of years ago. Collection and analysis are far more important because you're dealing in those instances with the nation's eyes and ears. And the nation cannot be blinded, it cannot be deaf in this world, which is increasingly small, increasingly interdependent, where it is increasingly more important that the decision makers in this government and in this country have available to them the best possible information about the intentions and the actions of other governments and other peoples. I have had, over the course of the 3 or 4 years that I've been involved with the Senate Intelligence Committee, I have had one dubious honor that I probably would have felt better to have passed, but didn't have the opportunity. And that was to be, for a couple of years, first couple of years I was on the committee, what was referred to as the spokesman for the Intelligence Committee. That is, that whenever the press had an inquiry, it came to me, and I was supposed to tell them either yes or no, mostly no. The man who, when Senator Boren, who I worked for, became a designee on the committee, I went to the committee to serve as his designee, to follow his interests on the committee, but also to serve, as all designees must on the Senate Intelligence Committee, a function for the committee as a whole. Senator Durenberger at the time was just coming in as chairman of the committee, and he came to me and he said, I noticed that you have been involved in the press a time or two in your checkered career, and I would like you to be the spokesman for the Senate Intelligence Committee. And let me tell you a couple of things about it. It's not going to be very hard. First of all, we never ever get in the press. Well, nobody ever says anything about what we do, and it won't take up very much of your time. Well, I swallowed that. I bought off on that, and I said, sure, Senator, I'd be happy to do that. And it ended up taking all of my time. Everybody was in the press all of the time, and we didn't get anything done but answer the telephone for about 2 years. That has changed somewhat under the tenure of Senators Boren and Cohen. And that is not meant to be, and I would not want anyone to take that as being a derogatory slap at Senator Durenberger. Senator Durenberger and Senator Leahy, when they were the chairman and vice chairman of the committee, operated on a somewhat different basis, but they were no less sincere about what they did and what they were trying to do than the current chairman and vice chairman did. Senator Durenberger had the idea, and I think at the time that he espoused it to me, it was a perfectly reasonable idea, and I think one that still is reasonable, that there are aspects of the intelligence business, the intelligence community, that can be made more public than they have been made in the past. It is possible to talk to the public more about what the intelligence is, probably more important or equally as important what intelligence is not, what this country does from time to time in the intelligence field, what the intelligence community is. There are certain aspects of that that I think could be talked about publicly, and I believe that he thought could be talked about publicly too. Unfortunately, as time went on, and as there came to be more and more of a conflict between Senator Durenberger and then director of the Central Intelligence Agency, Bill Casey, you know, that sort of thing kind of got lost in the noise and the rhetoric that was going on over those 2 years. But the basic idea was a good one, and I think that Senator Durenberger was very sincere in wanting to do that. I still think it's possible to do, and I think Senator Boren believes that it's possible to be more open in the matters coming before the committee than has generally been accepted in the past. We have held a couple of open hearings. We're going to hold a couple of more in the next week or two dealing with oversight legislation that is now pending before the committee. The one other point that I would want to cover, and I'm going to leave the Morrison case to my friend Mike McDonald here, who I'm sure has some strong feelings about it, and that is the responsibility end of what I was talking about earlier. I have had over the course of the last 3 or 4 years a number of times reporters, primarily reporters, who will say to me something of the following. It is not anything I can find out I can print or I can broadcast. It is not my responsibility to keep the government secrets. It's your responsibility. And if you can't do that, then that's not my fault. So if I find it out, I'm going to go with it. Now, I hasten to say that I would not ascribe that philosophy to a majority of the reporters that I have dealt with over the course of the last 3 or 4 years, but a significant number, a surprising number, and some surprising individuals who have said that to me or words to that effect over the course of these 3 or 4 years. And that is why I put in the line that I did at the beginning, that responsibility for maintaining a free society cannot be lifted from the shoulders of any member of that society. The media itself and writers themselves, whether they're in the media or whether we're dealing with private writers who freelance or private writers, have a responsibility to police themselves to a degree where national security matters are concerned. It's a very difficult job. One of the things Mort says is absolutely true, and that is that there is more kept secret than should be or needs to be kept secret. But the test is who makes that decision, who decides what is to be kept secret and what is not. And as he says, the process of doing that is a very messy one because it involves the government, it involves the media, it involves the courts, it involves the system. It is the system itself that is going to make the ultimate judgment as to what should be kept secret and what should not. Many of the reasons he gives on classification and so forth are absolutely correct. There are things that the committee has dealt with and has tried to deal with over the course of several years because things are kept oftentimes classified for no other reason than for a political one, and that is not right. However, it does take responsibility on all parts. It takes the responsibility of the oversight committees, of the Congress itself, of members of the intelligence community, of the administration, and of the media. Everyone must share in that responsibility. No one can take the attitude that it is not their responsibility where national security is concerned. And we can get into a lot more discussion about that a little later if you so desire. But I think I'll stop there and let Mike take on the Morrison case.
Our third speaker will be Michael P. McDonald from the Washington Legal Foundation.
And I should welcome you to the controversial part of the program now. I'd like to thank Writers Watch, and particularly Emily Sack, for inviting me to participate in the panel discussion. Borrowing a phrase that was made somewhat popular in the waning days of his ill-fated confirmation fight, should say that I harbor no illusions about changing any minds this afternoon, particularly among writers and journalists who don't seem to want to hear about balancing in the First Amendment context. I think by and large, at the J schools that they attend, the professors seem to dwell disproportionately on the somewhat literal view of the First Amendment propounded by Justice Black, that is, that the framers did all the balancing for us when they declared that Congress shall make no law abridging freedom of speech or of the press. Yet one need not be a Miesian disciple of original intent to recognize that such an absolute position has never commanded a majority on the Supreme Court, and I would concur with Professor Leonard Levy's remarks that it is an hallucination of sentiment that ignores history to assume that that's what the framers had in mind when they adopted the First Amendment. Indeed, we all know that the Constitutional Convention itself was shrouded in secrecy, and I wonder whether we would be here today as a nation with a document that had survived 200 years if the drafts had been routinely circulated in the popular press of the day. With 2.5 million employees having access to classified government information, I think it's fair to say that leaks to the press are always going to be a problem. And given the press's proclivity to publish secrets, regardless of the consequences, and I'd like to underline that, regardless of the consequences, we will doubtless continue to see cases arise in which courts are forced to engage in a balancing of interests between the First Amendment and national security. Now, let me say, of course, I believe that the press plays an extremely important role in informing society about the democratic process. And I certainly believe that the freedom to publish relevant information about the activities of our government is central to the protection afforded the First Amendment and is fully justified in principle. And yet, there are other interests at stake. Our society has a clear need to protect certain types of defense information. And I would throw the question on the table, should the press be entitled to disregard this need to protect national security information once it has managed to get a hold of such sensitive information? Should unelected and unaccountable members of the press be the ones weighing the official secrets, as the title of today's panel has it? In my view, the short answer to those questions is no. Journalists are citizens. Journalists have the same obligation as others to obey the law, and they have the same obligation that we all do to trust in the elected representatives of our government to operate properly. We operate in a representative system of government. I think the distinction is all too often lost, that the framers did not design a pure democracy in which everyone has an equal vote and in which one public employee of the government may take it upon himself to become the nation's conscience and leak information to a journalist who, again, may take it upon himself to become the nation's conscience and to release that information far and wide. Unfortunately, it seems, in recent years we have grown up, many anomalies have grown up in the law. It's somewhat curious that if a Department of Energy employee were to reveal closely held trade secrets or oil exploration data to a private company like, say, Mobil Oil, that employee could find himself automatically discharged and soon sitting behind bars along with Mobil's executives. But with some important qualifications I'll come to in a minute, qualifications that have largely come about because the Reagan administration came to town in 1981 with an explicit goal to cut down on leaks. An employee of the Defense Department who leaks classified information to a member of the press is probably not going to face criminal action, nor will the member of the press who publishes that information. Similarly, a government employee who is paid to steal secrets and pass them to a foreign government will, if he is caught, be subject to a vigorous prosecution. I think it's safe to say without any demurrals from the members of the press. But if a reporter obtains official secrets and publishes them to everyone who reads his newspaper, and the KGB have been known to walk across the street from their embassy and drop a quarter in the machine and pick up a copy of the Washington Post, suddenly the espionage laws are deemed totally inapplicable to the situation at hand. As I said, this situation has changed somewhat during the past few years. Yet the press is receiving and is continuing to weigh secrets and is publishing leaks with the same or greater frequency than it ever did. To go back to something that Mort Halperin said at the start of the program, I'd like to think that we can all agree that technical information about cryptographic techniques, intelligence gathering operations and sources, the designs of secret weapon systems, and so on, are appropriate subjects for prohibition on press disclosure. I'd like to think that, but unfortunately I can't. It seems that 3 years ago, in December of 1984, we saw the Washington Post run a story on a super-secret SIGINT satellite that the Space Shuttle Discovery was about to carry into orbit. The story described the weight and configuration of the satellite. It listed its purpose. It detailed the orbit of the satellite and had even published information regarding the sort of information that the American government was hoping to pick up from Soviet missiles. This was all highly technical information. Now, a half-dozen news agencies had the same story, including Aviation Week, and honored personal requests from the Secretary of Defense not to publish. Yet the Post did. Its defense? When someone tells us a report we are about to publish threatens national security, quote, we listen and we decide what to do. I find it somewhat pathetic to reflect that if the Post had obtained copies of the Redskins Super Bowl playbook, it probably wouldn't have published them out of some sportsmanship theory, but when national security is at stake, they're only too happy to put the material into print. I think the point to remember, well, the point that story illustrates is that there is very little consensus on foreign policy goals between the press and the government, or at least as much as existed, say, in the Second World War. To quote a good conservative friend, Pat Buchanan, to continue regarding the Washington Post as simply a newspaper is somewhat like regarding Rasputin as merely a parish priest. As an institution, the Post is partisan. The Post staff and the reporters on the Post contain several partisans who double as reporters. And I think the same is true at the opposite end of the spectrum for the Washington Times. And I would ask the liberal members of today's audience to consider how well they plan to receive leaks published by the Washington Times to subvert the domestic or foreign policy goals of the Cuomo or Gephardt administration after 1988. But it goes beyond liberal or conservative, although I think that's a highly animating factor in a lot of the decisions to publish classified information. The press, simply stated, has an institutional interest in breaches of confidence. Writers can't seem to understand that just as they have to maintain the confidentiality of their news sources, so the government at times has to maintain the confidentiality of its. I would agree with Morton Halperin that the government is very much a contributor to its own, to this problem. Overclassification has got out of hand, and leaks are coming from the top. I think of John Kennedy's remark that the American ship of state is the only ship that leaks from the top. And in the past few months, as we've seen Bob Woodward's book on Vail with the unauthorized disclosures made by Bill Casey, I can only wring my hands that such things would go on in this administration. But the point to emphasize is that it doesn't matter if the government is careless or intentionally or unintentionally stupid in mishandling information. The law doesn't grant immunity to a thief who breaks into a house merely because the owner happened to leave the door open. I'm only hopeful that in the future, two developments may change this sad state of affairs. One is the United States versus Morrison, that was mentioned earlier today, and the other is changes in personnel at the Supreme Court. I'm pleased to be able to say that whereas the American Civil Liberties Union, the law firm of Covington and Burling, and about 30 press groups all filed briefs trying to get the conviction of Samuel Morrison overturned at the Fourth Circuit Court of Appeals, that the Washington Legal Foundation was the only group to file a brief in support of his conviction and on the side of the government. I like the way Mort Halperin put it, that Sam Morrison merely, quote, gave information to the press. I think unspoken was the fact that he was in some sense perhaps furthering the people's right to know. As you know, Samuel Loring Morrison worked in a vaulted area at the Naval Intelligence Lab. He had a top security clearance, and he was regularly briefed about his fiduciary obligation to guard secrets. In order to get a job with a British publishing magazine, Jane's, when some classified intelligence documents, some photographs, satellite photographs, came across his desk, he took a pair of scissors, he cut off the secret designation on the photos, and he sent them to Jane's editors with notes intimating that perhaps he'd get a better job at Jane's. He was thinking of leaving government service. The government picked him up at Kennedy, it was either Kennedy or Dulles International Airport. They questioned him. They found out that he had lied, that he initially lied about having released the information. And then all of a sudden we see this full-blown First Amendment defense come up about Morrison was really trying to further the public's right to know. I don't buy it. I don't think that the judges of the Fourth Circuit are going to buy it. I think his conviction is going to be sustained, and I wouldn't be surprised if it's sustained unanimously. Lastly, I think that the 1988-89 term of the Supreme Court, perhaps not this term, is going to be a watershed year in the area of First Amendment jurisprudence and about the ability of the press to publish secrets at will. The 86-87 term of the Supreme Court marked an end. It was Justice Lewis Powell's last term. There were 11 free speech cases, and the government action was invalidated in 7 of the 11. Justice Powell was in the majority of all 11 cases, of course. He has been something of a swing vote for quite some time. We now have Justice Scalia on the court, and I think Justice Scalia takes a more common sense view of the First Amendment. If as I suspect, Judge Kennedy is confirmed, and if he is more sympathetic than Justice Powell was to the governmental interest and claims of national security, I think we can begin to see people like Scalia taking a more active role in remaking First Amendment law. And if that occurs, and if the proper cases are brought up, there is a case currently pending at the court involving prior restraint of the press, which I think would have very direct and immediate application to the press's ability to publish secrets in a Pentagon Papers type situation. I think we may be able to restore some rationality to this area of the law through the courts. And I'll end here and wait for the firestorm to erupt.
Our final speaker is my colleague from the nation, Christopher Hitchens.
First, condolences to all those who came here thinking that they were going to get Peter Pringle, whose mighty shoes I've engaged to fill, and who has put us all in his debt by his writing about the nuclear state and other aspects of British policy, though he also specializes in the melancholy distinction possessed by my country, which is being the prototypical home of the theory and practice of official secrecy and censorship, which is the subject I've been asked to address today. I have the same vanity as every other member of this profession, which is that I set some store by my reputation, at least for veracity, if not exactly for reliability. And I have a difficulty when speaking on this subject, especially in the United States, and speaking about the operations and the theoretical background of official secrecy in Britain, and the difficulty is simply stated. It's that I can tell often when I'm talking to American audiences that they think I must be making at least some of it up, because the merest sketch of the problems of political journalism in Britain, insofar as they relate to disclosures of officially held information, do, in fact, have the faculty of rendering the literary efforts of Joseph Heller and Franz Kafka amateur by contrast. You may have imagined yourself in a slightly fantastic world listening to Mr. MacDonald a moment ago and hearing about a mythical American press that doesn't seem to be the same one as gave the Reagan administration a completely free ride on national security at home and abroad and had to play catch-up to the evening edition of A Rag in Beirut in order to earn its condemnation from, I think you identified him as your friend, Patrick J. Buchanan. If you think that sort of allegation about a pretty tame and domesticated press in the United States is fantastic, you have yet to hear the opening periods of my remarks about Fleet Street. I'll start with an example that's both apt in itself and apt in the current climate of glasnost and perestroika. A matter of 5 weeks ago, the British government seized the English edition of the well-known morning newspaper Pravda. They seized this edition and forbade its distribution in the United Kingdom because the Pravda contained an article based on the by now really quite well-known memoirs of Mr. Peter Wright, former employee of MI6 Spycatcher. I have a slightly nunc dimittis moment when I read that. I felt rather as I felt when I saw Reagan described as a useful idiot for the Kremlin on Nightline the other night. I felt, I've lived long enough to see that said, and I've lived long enough to see Thatcher censoring Pravda in the interests of British national security. This is the moment, I think, of apotheosis for those of us who've studied the Official Secrets Act in operation. We already knew that any American or Canadian could buy and read Spycatcher. We already knew that though not every Soviet citizen had that privilege, that the Soviet intelligence authorities knew what was in it, the Albanian intelligence authorities knew what was in it, the Chinese, Hungarian, Polish, Bulgarian, and Czechoslovak intelligence authorities had all read it. We already knew that only we were not supposed to be allowed to read it, but we didn't know we wouldn't be allowed to read what they knew and felt about it. And there are some who don't think that this final flourish in the application of the law to national security was, strictly speaking, necessary. People who feel that this grace note, this coda, could have been spared us. But I take the contrary position. I think it is entirely and predictably in the logic of the Official Secrets Act and the ideology that undergirds it, that apotheosis should have been reached. How was it arrived at? You'll be aware of the fact that we don't possess a Bill of Rights in Britain. In fact, we have no rights at all. We only have traditions. And though traditions can be sturdy, and the tradition of English liberty, in my opinion, is a sturdy one and has to be upheld against such things as official secrecy, it is only a tradition, and you have no right of resort to the courts against government malfeasance in most areas. This is especially true in the area of information, and a distinguished British constitutional scholar, R.H.S. Crossman, cabinet minister and historian, amended Walter Bagehot's view of the English constitution as being that of cabinet government to one of prime ministerial government, where the prime minister was more than primus inter pares, but was more along the presidential monarchical model. And in the course of this study of the narrowing of British constitutional structure, defined secrecy as the essential English disease. He became an illustration of his own point when he attempted to publish his memoirs of being a cabinet minister in two governments, and was told by the House of Lords that there was no right for him to publish it, and there was no right for the English public to buy or read a book that detailed the workings of government as seen by a cabinet minister. In fact, that ruling wasn't set aside by the House of Lords until long after the author of the book had died. But that gives an example of the super-adjacent atmosphere in which these things are discussed. There is no right at all. There are occasional traditions very unevenly invoked. The supreme symbol of this want of right and unevenness of tradition is the Official Secrets Act. Official Secrets Act bears the marks of its birth. It was rushed through Parliament at a time of spy fever during the First World War, when the royal family, for example, was changing all its German titles to English ones and repudiating its German citizenship, and there was a tremendous wave of chauvinism sweeping the country, Dachshunds were found disemboweled in Hyde Park, all this kind of thing, a law was passed that said that anyone giving any kind of aid and comfort of any sort and so forth to the German branch of the British royal family, as in fact was the other side in this war, would suffer the full penalty of the law without being told why. Now this bill has been promised, well, it has been promised by every government elected since. This bill will be repealed since it is on its own face absurd and unjust, but every incoming government has found it unrepealably convenient. It is modeled on the dream of any state power. It is a law that permits the government to do anything, and it's thus not a tool which is likely to be easily discarded. And it gives me a terrible frisson whenever I do hear American conservative jurists speaking fondly or enviously of this, either of this bill as amended and enacted, or speaking fondly of the theory of secrecy that underpins it. The central provision, central aspect, the essence of the Official Secrets Act is its definition of secrecy. Its definition of secrecy is somewhat more extreme than the one Mort Halperin alluded to in his introductory remarks. It doesn't say that the government can define what is national security or is in the national interest. It says that the government can define what is a secret. I mean by this to say, and here's the point where I sometimes think people think I may be romancing the evidence somewhat, it means that it is no defense in a court case brought under Section 5 of the Official Secrets Act to prove that the information you printed was already in the public domain. That doesn't mean it cannot be defined as secret. I used to have to go around for nearly a month with a toothbrush in my top pocket about this very point, which is why I remember, and was in fact fully expecting and anticipating going to jail on it, because I don't know how many of you have been to London, but how many is a matter of interest? Well, even those of you who've only seen pictures of the skyline may recognize the Post Office Tower. It's the largest structure on the London skyline. Because the Post Office Tower is the center of a nexus of communications technology in Britain, it was ruled to be an official secret in the course of this trial in which I featured. Couldn't be mentioned in front of the jury, couldn't be entered in evidence as existing at all. Now, the fact that it was no defense for our lawyers to say the existence of the Post Office Tower, Your Worship, is not a secret. It is already in the public domain. It was defined for all purposes of the trial as location 1. The island of Cyprus, which is also a republic and a member of the Committee of Nations, where there are several British intelligence listening stations, which you can go to in a tourist car and drive up to the gates of, was defined as location 2. The island of Cyprus was ruled to be, its existence was ruled to be an official secret for the purpose of the trial. And that's not considered absurd, because it is the government. If the government loses the right to define what is a secret, then it will have to fall back on defining something as national security, which would be obviously much more arbitrary. The control, therefore, must be, and I think in all arguments of the kind put forward by Mr. MacDonald, inevitably is, the government must have the right to say what is a secret. Because otherwise the public domain defense in any pluralistic democracy will always be available. And if that is allowed, then the law is an ass, and that is precisely what a national security state may not or dare not permit. Therefore, of course, to be accused under the Official Secrets Act is axiomatically, ex hypothesi, to be found guilty, or rather, to be guilty. It's possible not to be convicted, but that's because the government simply cannot prosecute everybody who breaks it, since everybody in the practice of journalism breaks it necessarily every day. Collection of information, interestingly, is one of the phrases in the statute, one of the, searching for the right word, one of the charges of the statute under which you may be brought to trial. Collection of information is a heading under which you may be indicted. And that is, I think you'll readily see, a very difficult rap for a journalist to beat. Now, the reason why I think it's nothing to do with national security is this, and I have to mention another anecdote here. Because of this fact, a lot of British researchers, when they're looking into the history of British foreign policy and defense policy, have to come to Washington because there are archives on Britain available to them here that are closed in the Public Record Office. And one of the British historians who took this route when writing about the history of the British Secret Service was Andrew Boyle in his book, The Climate of Treason. And it was while researching in the United States what he was forbidden by law to read in the United Kingdom that he discovered a very interesting thing, which was that Sir Anthony Blunt, keeper of the Queen's pictures and honoured citizen, had been for the previous 20 years, a confessed KGB agent. Now, if he had published that in any English paper, two things could have happened to him, and probably both of them would. First, he would have been charged with breaking the Official Secrets Act by revealing the identity of a highly placed KGB agent who was protected by the British establishment. Second, Blunt could have sued him, and would have sued him for criminal libel, and would certainly have won. Aware of this, I did print that the missing fourth man was Sir Anthony Blunt in the New Statesman, in order to await developments. And it had the desired effect. I did it because the Official Secrets Act was being amended in Parliament at the time, and Mrs. Thatcher was well known to be very tender about it. And she was compelled to get up in Parliament and admit for the first time in 20 years that yes, it was true, Sir Anthony Blunt had been a KGB agent. Yes, a bargain had been struck with him. Yes, he hadn't been prosecuted. No, he hadn't betrayed anyone else. There'd simply been a cover-up. And it wasn't a cover-up, if you will allow me to say so, that defended British national interest from the KGB. In revealing that, she had to admit that the new amendments to the Official Secrets Act would have protected Blunt just as much as the previous act had done, and he would have enjoyed government support in bringing a case of criminal libel. I submit that that is of the same order of absurdity as the Pravda example that I began with, and that's why I think the Pravda example is not a farcical conclusion, but is in the nature of the theory and practice of official secrecy law. So I regard, in fact, official secrecy, among other things, as a negation of the proper conduct and supervision of national security. Now, I notice that I'll close with two Anglo-American examples for the sake of comity and internationalism. The first is the case of, it's another illustration of this, is the case of Edward R. Murrow, a great man in our profession and someone who many of us admire. When Ed Murrow came to London in 1940, and the United States was officially neutral in the battle against Nazism, he was anxious to try and alert the American listener to this problem, and found that at every turn when he asked, could he interview bomb victims, could he interview the inhabitants of civilian towns on the East Coast that had been shelled from the sea by the Nazis, could he talk to refugees from the concentration camps who were being processed in the Channel ports, at all turns he was told no, that the Official Secrets Act did not permit him to do this. All the broadcasts, the famous broadcasts that Ed Murrow made, that I think may be among the few examples of journalism altering the course of history, certainly altering it that much for the better, were made in defiance of a law that was designed to protect the national security of the United Kingdom, and that's an irony I think oughtn't to be lost by practitioners in the field. Secondly, I can never help but notice that when Republican politicians in this country are caught out fibbing, they tend to reach for a Churchillian example, and I noticed the other day George Shultz and Caspar Weinberger saying, well, as it was after the big disinformation campaign when this was, I'm sorry, after Mr. Monroe was after the press had decided not to take William Casey's word for everything. It was a regrettable period of lapse. After the Casey Poindexter disinformation, they said, well, as Churchill used to say, truth is so important that it needs to be protected by a bodyguard of lies. And I thought, well, they've got the bodyguard of lies bit right. But unlike Churchill, they are not seeking to deceive the Third Reich. Nor are they seeking to deceive anyone outside the borders of the United States of America. The bodyguard of lies is directed at their own people, as was evident in that case. And in closing, I would say, and would claim to say from experience, that you should never allow yourself to forget when considering official secrecy and its analogues, that you're the intended target of official secrecy. And those who doubt it, and those who swallow the patriotic defenses that are made for this absurd construct, are preparing in their minds, and trying to prepare your minds, to become model citizens in a national security state. And that's a destiny that I think you should reject while you're lucky enough to be able to do so. Thank you.
I'd like to thank all our presenting members here, and without wasting any more time, open the floor up to questions from you about directed to any of the participants. I would just ask that people identify themselves before they ask their question.
David Eisen, the Newspaper Guild. Mr. McDonald, you took some umbrage at the Washington Post statement that it, namely the Washington Post, would decide what the Washington Post would print. Keeping particularly in mind your concession about the vast amount of overclassification and the leaking at the top, who would you suggest should be the proper body to decide what the Washington Post should be able to print?
The point that I took, the point that I was taking umbrage at was the fact that the Post regularly and routinely receives stolen, classified, government originated information which the elected officials of this government and their representatives in the relevant agencies have determined that the release of which would be highly detrimental to the public interest and to the national security. I don't know that any of the editors over at the Post have the same degree of expertise or overview on the information that they receive to be able to make that decision. I'd like to see that the Post do something out of character, and that is listen to the Department of Defense officials for once if they tell them that release of the information would jeopardize national security. So I would leave that decision back to the elected representatives and the people in the relevant agencies with oversight of that information. I do not think that it should be made by Ben Bradley and his minions. I'm sorry, I just don't.
My name is Ann Swearingen, and I'm a freelance writer. And I don't want to sound like 1776 and all that, but I can remember learning in history years and years ago, probably before you were born, that one of the ideas of the Bill of Rights came before came from the reign of William and Mary. So I just wonder if Englishmen have only tradition and no rights, where did we get the idea that they came from that reign?
Very good question. In fact, we're about to celebrate next year the 1688 Glorious Revolution, as it was known. What I mean to say is that there's no amendment to which you can make a judicial appeal that says no law can be made to say this. The government, for example, can and does send what's called a D notice around Fleet Street. This notice says, if you become aware of the enclosed, or if you're already aware of it, don't print anything about it. Now, there is no way of taking the government to court and saying you mustn't do that, if you see what I mean. There can also lead to complications in the Official Secrets Act, because editors seeking to comply can say of an issue of defense spending, for example, will you please tell us what you don't want us to publish? That's been known to happen. Now, I would say that's bad enough, though it's what Mr. MacDonald regards as a model state of affairs, judging by his last answer. I'd say that was bad enough, but the government under the Official Secrets Act refuses on the grounds that if they told them which bits they didn't want them to publish, they'd be telling them what the secret bits were. So, no, we're not telling you. You've just got to guess. And what are people going to do in that circumstance? They're going to do what Mr. MacDonald, I suspect, wants them to do, which is not print anything at all and go for the royal family's outings with corgis instead. And then you have the model press of a national security state. And then don't complain. I mean, I know I heard you say, because I wrote down, that reporters, like everyone else, have an obligation to trust in the elected representatives of the government. I would say that was a very precise statement of what reporters don't have and citizens shouldn't have, the obligation to trust the government. This is pure servility. I crossed the Atlantic to get away from this mentality.
If there aren't any more questions, and I don't think there are, we'll close the session now, again thanking our presenters, and just want to remind everybody that there is a reception for members of Congress who have written books at the Mott House, which is across the Capitol grounds at 122 Maryland. That'll go on from 5:30 to 7:30 this evening.
Can you go if you're neither?
Yes.